is now in session.
Good morning. Before we call the case, I want to cover a couple of things with the attorneys. One, we appreciate you and your clients agreeing to this process of oral arguments by Zoom. This has enabled us to keep the court functioning and disposing of cases for the people of the state of Tennessee. We couldn't do it without the lawyers' cooperation, though, and so we appreciate that. If we should have any technological problems, we'll just take a pause and work through it. Things are working really very smoothly now, so we don't anticipate any, but if we do, we'll handle it that time. Call the case, please.
Jeff Druek versus Hydrogen Engine Center, Inc.
We'll hear from the appellant.
Good morning, Your Honor. I would like to reserve 3 minutes for rebuttal, as I told the clerk previously.
That will be fine.
Thank you, Your Honor. My name is Francis X. Santori, Jr. with the firm of Santori in Greenville, and I represent the appellant and individual Jeff Druek. The main issue we believe, Your Honor, is this, sort of twofold. Number one, when is a subsidiary liable for the debts of its parent? And number two, in this case, is the subsidiary liable? And we believe most respectfully the answer is yes. Briefly, the facts in this case are this. The appellant, my client, the individual, loaned Hydrogen Engine Center, Inc. $100,000, and a promissory note was issued in 2010. That note was defaulted on, and my client sued in the courts of Iowa in February of 2016. The defendant, Hydrogen Engine Center, Inc., and we'll get into this in a second, appeared and contested a summary judgment motion in the later part of 2016, and that was denied. Another summary judgment motion in the Iowa court was refiled in the following year, and it was granted without any visible opposition. Now, I was hired in 2019 last year because my client had discovered what it thought were some assets of the parent corporation through its subsidiary. And in attempting to discover assets, we found that there was what we believe to be, and I think another crux of this argument is that Mr. Nunley holds to the opposite, Judge Sweeney, a wholly owned subsidiary of Apelli, a corporation by the name of HEC-Tina, had been operating in Greene County. This is a corporation, as well as all its parents and subsidiaries, that are engaged in one thing, Your Honors, and that is to try to manufacture energy through different processes, or through one process, in this case, trying to extract hydrogen out of water. And it's sort of a fascinating process, but they've been sort of unsuccessful with respect to it. The relationship of all these companies to each other were spelled out in a joint news release, which is shown as Record Volume 1, pages 21 and 22. In fiscal year ending 12/31 of 2005, the Apelli filed its 10 KSB form with the Security and Exchange Commission. It was introduced by my worthy adversary, Mr. Nunley, at his Rule 60 hearing in November of last year. And that's at Exhibit Volume 1 of the exhibits, page 5 through 30, or Exhibit 2 of the 10 exhibits jointly filed. What is most remarkable about this filing is that although it says HEC-Tina is a Nevada corporation, it admits HEC-Tina does business in Iowa with its situs and principal place of business there. The corporation, HEC-Tina, had purchased land in Iowa. The Form 10 KSB stated that Hydrogen Engine Center, Inc. had merged with a, and I'm quoting from it, Your Honors, quote, newly formed subsidiary, which was not Hydrogen Engine Center, Inc., Iowa, but Hydrogen Engine Center, Inc., Nevada. Hydrogen Engine Center, Inc., Iowa stayed in business until 2018. Its right to do business, Your Honor, and that of its, what we believe its subsidiary, HEC-Tina, was either administratively dissolved or never active in Tennessee at the time of the attempted domestication. Actually, it is the domestication of the foreign judgment in this case in September of 2019. Mr. Nunley, doing his usual good job, went ahead and reinstated the corporation. And obviously, it had effect as to the acts that the corporations may have taken. But when we don't have a service of process agent, how can you get service of process? I ask rhetorically, and that will be discussed later on. As a result of the
Interrupting Mr. Santori, I have a couple of procedural questions. As I understand, this appeal is appealing the entry of 2 orders by the trial court. Is that correct?
Judge Frierson, I believe that you are right. It is an order that grants the Rule 60 relief, and it's an order that I think dismisses the case. Am I correct?
With reference to the orders which have been appealed, did the trial court make any specific findings of fact or conclusions of law?
No, the trial court did not make any specific findings of fact or conclusions of law, but Judge Frierson, and I want to be candid with the court, we had gone up to Sneedville, which of course the court knows very well. And we had this hearing in Sneedville, good place, but somewhat, you can't get to it from here. We had gone up there, Mr. Nunley presented an argument. At the time, I stepped out, basically said, and I'll be very honest with this court, and said, well, maybe this company doesn't have enough assets to go after, so we'll just let you go ahead, although it wasn't seen as an agreed judgment. We'll let you go ahead and take your order. So I must be honest with the court and say that. However,
Excuse me for interrupting again, would it not be necessary for the trial court to make specific findings of fact and conclusions of law for this court to review on appeal?
well, it certainly would be with any particular judgment, if Your Honor pleases. Now, again, I'm telling the court honestly what I did because I don't want to mislead the court. Later, after I spoke with my client, it turns out, and this is an attorney-client privilege conversation, that there may be some other assets. But to answer your specific question, that is exactly right. But I do want to tell the court what happened with respect to this. You're exactly right. Under Rule 59, and I think under Rule 60, you would have to, and under Rule 56.
And the orders which are on appeal specifically granted intervention and quashed a levy, correct?
That's right. I'm sorry. That is correct. They granted the intervention and they quashed the levy.
And there, I presume, are a number of facts in dispute in this case?
There are facts in dispute in this case. Yes, Your Honor.
Thank you.
All right. Thank you, Your Honor. Okay. And finishing the factual basis, if it please the court, quoting from the Form 10 KSB, this corporation or the various corporations, Heck Nevada, Hydrogen Engine Company, Nevada, assumed all the operations, assets, and liabilities of Heck, Iowa, and Heck, Canada. That is a direct quote from that particular form filed with the SEC, albeit in 2005. And basically, just to go on, I was retained to domestic.
Sir, is that a part of the record on this appeal?
Yes, it is, Your Honor.
Okay.
The Form 10 KSB is. In fact, it is found again at volume 1, pages 5 to 30 of the record, or it's also marked as Exhibit 2 of the 10 exhibits that Mr. Nunley and I marked.
Okay. Thank you.
I thank you, Your Honor. Okay. We, just to short circuit the facts, which I know you all have read, it was difficult for us, as I said, to try to get service on this individual, on these corporations, various corporations. We domesticated a judgment. We had no opposition. I filed a motion to sell the real estate pursuant to Rule 69, met with no opposition, set it for a certain date. And then, of course, after that point, everybody hired counsel. And I do want to say that I did notice all the corporations in and the bank which held the note on it. This is to sell the real estate, and the tenant to some of the real estate, contrary to what was said in his brief by Mr. Nunley. Okay. Your Honors, very briefly, we believe that the legal argument allows us, and this is not a piercing of the corporate veil case, contrary to what appellee may say. When a corporation is organized to take on another's business, it may become liable to the creditors, and the liability may be either implied or expressed. That came from the Oklahoma case that I cited on pages 14 through 15 of the brief. Now, Your Honors, we do understand, as stated by Mr. Nunley in his brief at page 17, that the Gordon versus Greenview Hospital case say that parents and subsidiaries are presumed to be separate entities. However, Tennessee law does not necessarily insulate a subsidiary, from the parent's debts. There's estoppel questions and questions of equity. And in the three cases that I pointed out to the court, Tennessee Consolidated Coal versus Home Ice and Coal Company, American Indemnity versus Southern Missionary College, and the Nice versus Fireman's Fund insurance card case, where you have basically a disregard of a corporate entity, same officers and directors of a corporate entity, where two corporations, even though corporate entities were so intertwined as to be one, then one is basically liable for the debts of the other. Here in this case, you don't have a situation like, say, with Delco, a division of GM that manufactures batteries, and GM, which manufactures cars. All of these companies are participating in the same business. They're controlled by the same people. They have basically the same stockholders, and they were designed basically, and we say this with all due respect, to insulate themselves as much as they could from the legal debts of each of them.
Counsel, is there anything wrong with that?
Oh, your Judge Sweeney, there's nothing wrong with that. In fact, I would dare say that obviously we all even form professional corporations ourselves to do that. I certainly do understand that. But we're not, I think, most respectfully to the court, that's somewhat, and please don't get on me, a comparison of apples and oranges, because that's a person in that case, or a self-employed person trying to put himself or insulate himself from liability as a corporate entity. Here we have two corporate entities. Yes, they're presumed under Tennessee law, but that presumed to basically insulate each other from liability. But when you look at their corporate structure, and we believe that this corporate structure factually shows a lot of things that shows that we can disregard the normal parent subsidiary, particularly, Judge Sweeney, when they say in their own filings, we're responsible, we take over the assets and the liabilities of the other corporation. Now that's right there.
Okay, thank you, counsel. You have your time left for rebuttal.
Thank you, Your Honor.
We'll hear from the appellee.
Thank you very much. This is William Nunley of the Greene County Bar. I represent the intervenors in this case, which is Hectina, Inc., a Nevada corporation that was registered to do business in Tennessee. It is not a Tennessee entity. And I represent Plastic Innovation, Inc., which was a tenant of the Hectina Real Estate in Greene County. First, I have to take issue with several of the recitation of the factual background here. First, this was not a Rule 60 hearing. This was just a motion to intervene in the case on behalf of necessary parties who had not been made parties, and accompanied by a motion to quash a levy of execution to sell real property of a non-party. Mr. Santori erroneously stated that Hectina is described as coming into existence in a 2000, that its corporate status was described in an SEC filing in 2005. That's incorrect because Hectina was not even formed until 2014. The 2017 SEC report, which was also produced and shown to the court, is where the explanation of Hectina's being a subsidiary can be found. Likewise, if it did not exist in 2005, Mr. Santori is in error in saying that it owned Iowa property. It didn't exist in 2005. It didn't exist in 2014. The note was signed in 2010. The actions were taken in Iowa in 2016 and 17. So I don't think this is a Rule 59 motion where recitations of fact and law are required. What happened here is we were there with live witnesses on behalf of Plastic Innovation and on behalf of Hectina. One of the gentlemen, Mr. Hedges, had driven from the Connecticut, New York City area for the hearing. The other gentleman was from Greenville. It was in Sneedville. So after a lengthy recitation of the facts and the presentation of certified copies of Iowa documents, Nevada documents, and Tennessee documents explaining the corporate status of everything, it became clear that my motions would be honored, and we could have put on proof, but we were called into chambers, and Mr. Santori conceded that the motion should be granted. Now, let me explain. I'm sure the court probably has absorbed it. This was not a civil action that was designed to pierce the corporate veil. It was a mere filing of a foreign judgment. In the old days, we called that a domestication of a foreign judgment, and I still think of it that way. But it was a notice of filing of a judgment taken against an Iowa entity called Hydrogen Engine Center, Inc., but it was an Iowa entity. At the time of its formation, what is now Hydrogen Engine Center, Inc. of Nevada was actually called Green Mountain Labs. It was after the Iowa entity, and it became a parent subsidiary relationship, that the parent company adopted the name and became Hydrogen Engine Center, Inc., a Nevada corporation, but the Iowa entity continued to exist.
Excuse me for interrupting, Mr. Nunley.
Sure.
With reference to these two orders, are they consent and agreed orders which were entered by the parties?
Yes.
So was it necessary for the trial court to make factual determinations with regard to any of the disputed facts?
Well, I don't know that the facts are very much in dispute, but no is the answer to your question. As I set forth in the brief, and as the transcript shows, I brought two orders with me that day. One to be designed more or less for the judge to enter if he ruled in favor of the motion to quash with a just certificate of service to Mr. Santori noted on it, and the order that was entered, which was an order entered by consent of both attorneys for the litigants.
Were these consent orders entered on the record after the parties were sworn?
Yes. On November 1 was when the hearing was. The order was signed by the judge on November 1, or the orders were signed by the judge on November 1, although since it was in Sneedville, they didn't make their way to Greenville for actual entry into the file in Greene County until November the 8th. And then the notice of appeal was filed on December the 4th. Well, the interesting thing about the entire background was this Iowa entity owned no assets in Tennessee, and yet here is an order being domesticated as though it was going to be enforced against Tennessee assets when it had none. Second, the parent company, Hydrogen Engine Center, the Nevada Corporation, had no assets in Tennessee. So when the document was filed, the pleading was filed by Mr. Santori, he described Nevada Engine Center, Inc., but noted that it was a Nevada corporation. Well, there is a Nevada corporation by that name, but it was not the defendant in the Iowa case where the judgment was taken. But neither of those entities, the Iowa entity or the Nevada parent company, had assets in Tennessee. Then Mr. Santori proceeded to attach the real estate of a entity, Hectina Inc., which was not formed again until 2014. It did own a commercial facility in Greene County, but it was not a party to this action. And yet he filed a levy of execution to padlock and sell property of a non-party. Again, it is a subsidiary that was never made a party until I intervened on its behalf to say, wait a minute, this is not a party to this action. You're domesticating a judgment. You're not piercing the corporate veil. This is not an action that has you might say, a multiple headed dragon type action. It was a rifle shot, just to file and domesticate a foreign judgment. But anyway, he then leapfrogs from the fact that there was a judgment against an Iowa entity who he never mentioned in the pleadings anywhere. You will not find Mr. Santori noting the existence or even acknowledging the fact that this judgment was against an Iowa entity. But then he then leapfrogs and says, well, all right, I've got a judgment here. I'm going to say it's against this Nevada entity, which it wasn't. But then I'm going to make another leapfrog down to Hectina without making it a party. And so obviously it was seriously flawed, and obviously we had to intervene to put a stop to it. Otherwise, there could have been a court sale ordering the sale of property of an entity that it was not before the court. I mean, as they say in East Tennessee, can they do that? And the obvious answer is no. So he never pled it. So there's some serious flaws here, and there's 5 of them. Number 1, Hectina, the judgment debtor, was Iowa entity, was not made a party. 2, even though it was supposedly a domestication of the judgment against it. 2, Hydrogen Engine Center of Nevada was named as a party, but not served with process. 3, Hectina Inc., whose assets he sought to sell, was never made a party until I intervened. 4th, Apex Bank, that in the pleadings that Mr. Santori filed, he acknowledged that it had a large lien against the real estate and that he was wanting to sell, and he didn't make it a party. And finally, Plastic Innovation, whose existence he acknowledged and as a lessee. And in his pleadings, he described them as defendants and respondents when they were not defendants and they were not respondents. So because he notified them or sent pleadings to Apex and Hectina of what he was doing, that is what then led to communications from a executive at Hectina, and it also resulted in Apex initiating a foreclosure. So the foreclosure was scheduled for early November. So we hastily got ready for the November 1 hearing, and the folks were there. The documents were produced saying that in effect, they were opening statements, Your Honor. And so what I was introducing these various documents to show is when we put on our proof, Your Honor, this is what you will see, and this is what is going to come into evidence. At that point, we were called into chambers, and Mr. Santori conceded that the motion should be granted. And then less than a month later, after the entry, he appealed them. Now I have filed a couple of motions that indicate that those actions on his behalf have interfered with the contractual sale of the property from Hectina to originally perhaps Plastic Innovation, but they didn't have the financial power to do it. So its parent company called Package Express Center, Inc., which is an entity that you would have been familiar with back when you were our trial chancellor, became the purchaser of that property, and so that the lease of its subsidiary would remain intact and business would go on. So a few months later, after Mr. Druek's counsel indicated that he would back off and not interfere with this sale, he appealed and it would not sign that agreement. And so in March, we decided, well, perhaps the bank would allow a loan assumption to take place, which would get over a title insurance problem. If you had a new loan and a deed accompanied by a new loan with this appeal hanging on, there was a cloud on that title, and no title insurance company would touch it with a 10-foot pole. But if it was a loan assumption of an existing insured loan, then there didn't have to be new title insurance. So it took a while to get through it. But my second motion shows my motion to introduce post hearing facts is that there was a closing in August the 20th of 2020, which I had the duty to report to the court before this hearing. So he has not filed a piercing the corporate veil action, and yet he's attempting to pierce the corporate veil to get to the assets of an entity that is not even before the court until I filed an intervention on its behalf. Now, if you get into what is necessary to pierce a corporate veil, the court is no doubt familiar with the 11 Allen factors and the Continental Bankers case, which in my opinion are the two leading cases on piercing the corporate veil in Tennessee. And of these 11 Allen factors, if you go through them, he can't meet even, but maybe one. The fourth Allen factor is sole ownership of stock by one individual. But the rest of them, where there's a failure to collect paid-in capital, whether the corporation is grossly undercapitalized, the use of the same office or business location, the existence of the same employees and attorneys, the use of the corporation as an instrumentality to conduit an individual or another corporation, the diversion of corporate assets to a stockholder or other entity to the detriment of creditors, or the manipulation of assets and liabilities. 9, the use of the corporation as a subterfuge in an illegal transaction. 10, the formation and use of the corporation to transfer an existing liability to another person. And finally, the failure to maintain arm's length relationships among the related entities. Well, it goes on to say, though, that even if, aside from can they meet those standards, another requirement is that there be fraud committed by the entity against whom the effort is undertaken. And what fraud has Hectina committed? It didn't even exist in 2010 when the note was signed. So how could it be engaged in some sort of fraud? It had nothing to do with the duty to repay the note. So there's no fraud there. So in the clear Tennessee authorities, had he tried to pierce the corporate veil, which he didn't do, there would not be even the ghost of a chance to do that. But yet, without attempting to even prove that he could pierce the corporate veil, he goes ahead and conducts himself as though he could conduct it without even making them a party and then selling its assets. It's just the most absurd thing. With all due respect to my friend, Mr. Santori, it's one of the most absurd undertakings I have ever seen. Now, in his conclusions, he reaches 6 conclusions at the end of his brief, and then says all of them are affirmative. And in truth, none of them are. He says in conclusion, was Hydrogen Engine Center, Iowa and Hydrogen Engine Center of Nevada operating as one and the same? There's no proof of that. 2, were the distinct entities of HEC, Iowa and Nevada never disclosed to the appellant? Well, he sued the HEC entity in Iowa. Then he sued the HEC Nevada entity here in Tennessee by trying to domesticate a judgment. And now he says that he didn't know that those were entities and that those weren't disclosed to him. It's absurd. 3, did not the filings of SEC Nevada with the SEC indicate the debts of HEC Iowa were to be the debts of HEC Nevada? Yes, in 2005 for existing debt, but no indication that it would be responsible for any future debt. In 2010, the Iowa entity signs Mr. Druek's note. 4th, he says, were HEC Nevada, HEC Iowa, and Hectina in effect one entity? There's no proof of that. They're separate shareholders and other things that show up in that SEC filings. HEC Nevada is a publicly traded company with hundreds of shareholders around the world. HEC Iowa is a subsidiary of HEC Nevada, and Hectina is a subsidiary formed much later, but did acquire property in Tennessee. So they're not the one and the same. There's no proof of that. 5th, he says, was the subsidiary Hectina wholly owned by HEC
Counsel?
You can read them, but thank you. I'm out of my time.
Yeah, your time's out. We'll hear from the appellant rebuttal.
All right, thank you, Judge Sweeney. In the 3 minutes that I have for rebuttal, with respect to this, again, we must respectfully disagree with Mr. Nunnally. We have, I think, shown to this court most respectfully that these three entities, Heck Iowa, Heck Nevada, and Heck Tina, so we'll call them Iowa, Nevada, and Tina. Iowa and Nevada merged into each other. Tina is a subsidiary of Nevada. They're both engaged in doing the same things. They were running the same things, doing the same business. Iowa's debts are Nevada's debts. So with respect to this, now, if that weren't the case, then why was Iowa borrowing money from Mr. Druek in 2016 if they weren't an entity? See what I'm saying? I think that's that's sort of a can you believe that type of thing. To end this with a quote, and I'm quoting, Your Honors, from the distinguished Professor Fletcher in his great cyclopedia on the law of corporations, and this comes from the Nice case. I won't say the entire quote, but quote, a very numerous and growing class of cases wherein the corporate entity is disregarded is that wherein it is so organized and controlled and its affairs are so conducted as to make it merely an instrumentality, agency, conduit, or adjunct of another corporation. The control necessary to invoke what is sometimes called the instrumentality rule is not mere majority or complete stock control, but such domination of finances, etc., that the control corporation has no separate mind, will, or existence of its own. What is merely a business conduit for its principle. I'm paraphrasing now. One corporation may be disregarded.
Counsel, won't you move your right hand? I think you've got the camera.
I'm sorry, Your Honor. Thank you. Thank you. I'm trying
Go
to
ahead.
balance. Okay. One corporation may be disregarded where the two are identical or indistinguishable, unless it's a mere instrumentality or agency or adjunct in that sense, or as a sham or is used in fraud by the dominant corporation, it will not be disregarded. We think that it has to be disregarded here, and that's the whole crux of our case. And we ask that this honorable court overturn the circuit court's orders of November of last year. Thank you. If the court doesn't have any other questions, I am finished with my argument and my rebuttal.
With reference to the two orders which were entered, were they entered as consent agreed orders by the parties?
Yes, Your Honor, they were agreed orders. And I think that I inartfully, and if I may have a few seconds over my 3 minutes to answer Justice Frierson's questions, I think that I sort of inartfully explained to you earlier in my main argument what it was that we were trying to do. Normally in a Rule 59 or 60 case, you would have to have findings of fact. These were agreed orders on what Mr. Nunley said, and he's exactly right. Number one, it was a motion to intervene, and number two, it was a motion to quash the execution upon the real estate. They were agreed orders. Yes, sir.
Thank you.
All right, thank you.
All right, thanks to counsel for both sides. We appreciate your briefs and your oral argument this morning. Madam Clerk, if you will, please recess court till 1:30 this afternoon.
This
Thank you, Your Honor.
honorable court is in recess until 1:30 p.m.
Thank you.
Thank you all.
Thank you. Thanks, Bill.
Please, Frank.
All right, bye-bye. Okay.